Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Drug manufacturing lawyer in Chicago. A felony offense in Chicago. Drug manufacturing involves producing, preparing, mixing, processing, or packing controlled substances for sale. If you are being investigated for, or if you've been charged with drug manufacturing, you need to retain a Chicago drug defense lawyer immediately. At Combs Waterkotte, we have experience handling a variety of drug-related cases, and we can put our more than 60 years of combined legal experience to work for you. For the aggressive legal defense you deserve in your corner, don't hesitate to call our Chicago criminal defense lawyers now at 312-500-HELP, or contact us online for a free consultation. What is a drug manufacturing charge in Chicago? Prosecuted under the Illinois Controlled Substances Act or the Methamphetamine Control and Community Protection Act, manufacturing is usually charged as a felony, ranging from a Class 4 to a Class 10. The severity of the charges will depend upon the type of drug, the quantity of drug, the location of the activity. While manufacturing less than 15 grams of methamphetamine is a Class 1 felony, manufacturing 15 grams or more is a Class 10 felony. Similarly, it is a Class 10 felony offense to manufacture the following controlled substance: heroin, cocaine, etc., amounts 15 to 99 grams, 100 to 399 grams, 900 plus grams. Penalties for drug manufacturing in Illinois. Depending on what felony offense you are facing for drug manufacturing, you are looking at the following penalties. For manufacturing 15 grams of meth. This Class 1 felony offense comes with 4 to 15 years in prison. For manufacturing 15 plus grams of meth. This Class X felony offense comes with 6 to 30 years in prison. It can also be increased to a 60-year sentence, depending on the amount. For manufacturing 15 to 99 grams of a controlled substance, this Class X felony offense comes with 6 to 30 years in prison and up to a $500,000 fine. For manufacturing 100 to 399 grams of a controlled substance, this Class X felony offense comes with 9 to 40 years in prison and up to a $500,000 fine. For manufacturing 900 plus grams of a controlled substance, this Class X felony offense comes with 15 to 60 years in prison and up to a $500,000 fine. With such serious penalties on the line, it is imperative that you quickly retain aggressive legal representation in your corner. Aggravating factors in Chicago drug manufacturing cases. The penalties you are facing can be enhanced if the manufacturing occurred near the following locations: a school, a park, a place of worship, public housing. Additionally, if a child was present or involved during the drug manufacturing, you can also face enhanced penalties. Larger quantities and/or a large distribution network and harder drugs, such as meth or heroin, can also result in a more serious felony classification. Other factors that can result in you facing more elevated charges/enhanced penalties include previous drug convictions, possession of specialized lab equipment, large amounts of precursor chemicals, manufacturing in a way that creates a fire/explosion risk, environmental hazards from chemical disposal, evidence of intent to distribute, not just manufacture. How are drug manufacturing cases investigated in Chicago? In Chicago, drug manufacturing is taken seriously and investigated by several different law enforcement agencies, including DEA Chicago Field Division, Chicago Police Department, Illinois State Police, and CBP Chicago. Common tactics used in a drug manufacturing investigation include surveillance and monitoring, confidential informants and undercover operations, search warrants and property searches, clandestine lab response, the specialized police and hazardous materials investigation triggered when law enforcement suspects illegal drug production at a property. Digital evidence collection. Because a drug manufacturing case involves a thorough investigation, and from the start, prosecution begins building a strong case against you. You need to speak with a Chicago drug defense lawyer to ensure your rights and future remain protected. Your rights after a Chicago drug manufacturing arrest. You have constitutional rights that can protect you from law enforcement overreach. Following a drug manufacturing arrest in Chicago, you can invoke the following rights. The right to remain silent. Under the Fifth Amendment, you can refuse questions about the drugs, where they come from, or your alleged illegal activities. The right to an attorney. Under the Sixth Amendment, you have the right to legal counsel, and you do not have to speak with police or prosecutors without your attorney present. Protection against unreasonable searches/seizures. Under the Fourth Amendment, you have protection against unreasonable searches or seizures. This requires police to have a valid search warrant or probable cause to search your home, person, or vehicle. Right to refuse consent. You do not have to consent to a search. You can directly state to the police, "I do not consent to a search." When you retain legal representation, your Chicago drug defense lawyer will make sure you don't do anything to compromise your rights or jeopardize your case. Common defenses in Chicago drug manufacturing cases. Illegal search and seizure. If police lacked a warrant or probable cause, then evidence may be able to be suppressed under the Fourth Amendment. Lack of knowledge or intent. If you did not know the drug manufacturing was occurring, or if you weren't directly involved in the process, then this defense may be able to be applied to your case. Entrapment. If law enforcement induced or coerced you into committing a crime you wouldn't otherwise have committed, then entrapment may be applied as a defense in your case. Constructive possession. If others had access to the location, we may be able to challenge whether the drugs, such equipment, belong to you. Mistaken identity. This defense is used when we are able to prove that you were not the person involved in the illicit activity. Challenging evidence. Handling. If the chain of custody or accuracy of laboratory tests is questionable in your case, we may be able to challenge evidence handling and get it suppressed. Can Chicago drug manufacturing charges be reduced or dismissed? In some instances, drug manufacturing charges may be eligible for reduction or dismissal. Our Chicago drug defense attorneys are experienced with negotiating plea agreements, reducing felony class level. We fully investigate your case, challenge evidence, and seek dismissal if your constitutional rights were violated, improper police procedures were followed, or if there is insufficient evidence against you. Alternatively, if you have minimal criminal history, we may be able to get your charge reduced to a lesser offense, such as possession. When reduction or dismissal aren't options, you might still be eligible for alternative sentencing such as diversion or rehabilitation programs. Because every drug manufacturing case is fact-specific, it is advised that you reach out to us for a consultation as soon as possible, so we can evaluate what your strongest legal options are. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.